Good morning, everybody. This is a meeting of the House Criminal Law Subcommittee. We have a few bills that we have been discussing that I hope we're going to move today. I would like to start with Delegate Lewis's body cam procurement bill. If we can get the folks who we need for that already in the room?
They are now.
Okay, great. Colleagues, this was a bill to create a process by which the state would have larger contracts potentially for body cam procurement that other smaller police departments could piggyback onto to try and achieve some savings. And there was an amendment from the sponsor, which you should have all seen, to specify that I believe DGS would be the responsible entity. And I know there was some discussion about that, but I am told that everybody's fine with Delegate Lewis's amendment and having DGS be the designated entity. If we could just get, yeah, we have Delegate Bartlett, go ahead.
Just a quick question for clarification. I want to make sure we're talking about House Bill 332. Or is it another one of Delegate Lewis's?
Yes, that is the one.
Okay, and so, okay, so I see where DGS is added, but I also see where we're adding do it. Is that an old ad? I mean, that was already in the bill?
Hold on.
Because I'm looking at it in the interlineated.
There's two sets of amendments from Delegate Lewis that were attached in the email.
Okay.
Can I share my screen?
Yeah, why don't we put them up on the screen if possible? So we
Thank you. Thank you, Mr. Chair.
There's actually reprints of these amendments, which are easier to
follow.
see. Yes.
Yeah, okay. Okay. And so, right, so this is about studying whether it's feasible to have a statewide system for doing this instead of splintering it into multiple vendors. Which I know, there was all this stuff came out of a few years of maybe a year or two of discussions on I think it was an info, I can't remember, it might have been a code designated task force or work group. And I sat there with Delegate Lewis and multiple law enforcement agencies, and just to explain why this provision is in here, it does seem like it would be easier and cheaper to just have, large contract or something like that. But we already have some police departments that have gone with small vendors, and they didn't like the idea of being forced into being forced to do a new vendor. So this question about whether it was even feasible was put in as a study. Delegate Erican, your hand is up.
Yeah, sorry, I couldn't find my button. I just want to make sure all the stakeholders were on the same page with these amendments because they seem fine to me as long as there was no issues raised by any, like. were
Yeah,
chiefs and
this all
sheriffs
seems
able-
fine to me. So do we have the agencies here to just give us the thumbs up that everyone's cool doing this? Jamie, sorry, I can't pronounce your last name, but if you want to unmute, go ahead.
Hi, Jamie Tomaszewski, Chief Administrative Officer for the Department of General Services, Office of State Procurement. From the Department of General Services perspective, we are happy with the amendments and look forward to this bill.
Okay, excellent.
Do we have
And I-
chiefs and sheriffs or anybody like that?
Yes, hi, Andrea Mansfield representing the chiefs and sheriffs. Yes, we've also reviewed the amendments and we are fine with them too.
Awesome. Then
My
I'll
client is
go
fine.
ahead and move favorable on these amendments.
Second,
All right, so these amendments are before you. All in favor of adopting these amendments, raise your hand. Does anyone want to be recorded in opposition? Great. Okay. Do we have a motion on the bill as amended?
I
Move favorable.
Mr. Chair.
Second,
All right, all in favor of this bill as amended, raise your hand. Does anyone want to be recorded in opposition? No. Okay, great. Thank you. We will move on to Delegate Love's bill on person in a position of authority having relations with a minor. To pick up our conversation from last week, there were 2 rounds of edits that went into this. Claire Rossmark, our counsel, did 1 round, which was simply attempting to take the bill as introduced and to make it more workable but preserve the intent. So that was the first thing we did. And then we worked through in last week's work session some basic questions about how we wanted to phrase some of the items here. So you should have all seen the reprint with the work from our discussion last week, as well as Claire's technical edits incorporated into the document before you. So if anyone has any questions or concerns about anything that we discussed or put into this part, now would be the time to raise it, because I just want to have a very quick discussion about the one piece of this that we left for this week, which is about prior relationships with the students. But before we get to that bit, does anyone have any remaining questions or concerns about all of the other aspects of this bill? Okay, it doesn't sound like it. So can we scroll down to just that part about previously rolled? All right, here we go. So if you look at in sub 2 numbers 1 in Roman numerals 1 and 2, this was the part that Claire had just pointed to that we didn't really get into. And so I just want to make everyone aware of what the question is here. Basically, it seems very clear to me if the student is in the program and fits the criteria, the age criteria, that this is impermissible behavior. And the bill also includes that if they leave the school or program, it also becomes impermissible behavior. So I just want to point to that. I think that the only interesting thing about it is that 2 people in similar circumstances could be engaging in illegal or legal behavior, depending on whether the person was formerly a student or not. If people catch my drift, that I guess if someone was not a camp counselor and they were 16 in a day and 20, that wouldn't be illegal in Maryland. But if ever they were at the same camp, it would be illegal. So just FYI, that's That's in the bill. I see 2 hands. Delegate Erican.
Thank you. Yeah, so I'm just looking at it again. I'm sorry I didn't bring this up last time. Can Claire maybe tell me why we just included vaginal intercourse? I'm worried that we're missing like lots of other sexual behavior. It's on page 3. I'm sorry, I couldn't hear you. So on page
It's
3.
all in there. If you're looking at the reprint, the
Yeah, so look at the
bill as
reprint.
introduced had some problems in this area, but if you're looking at the reprint, yeah, it's, so paragraph 1 includes the sexual act or sexual contact. Paragraph 2 includes the vaginal intercourse. So it's all
Okay.
possible sexual activities included. It's just separated because the statutory references
Okay.
refer back to statutes that only deal with those specific types of
Okay.
behavior.
Okay, so the bill does protect both male and female children.
Yes.
Okay, awesome. Thank you.
All right, Delegate Cardin and then Grammer.
Thanks. I just, can you hear me?
Yes.
Okay. I just want to make sure I understand correctly. So if there is a counselor who's 20 and
A person in a position of authority has to be 21.
okay, a person who's 21 and a 16-year-old, and the 16-year-old is the camper, and that all of a sudden that would be a criminal act. This is making that a criminal act, right? If they're having some kind of sexual relationship. But if the camper is a camper in a different camp, it's not a criminal act. Is that correct? 16 in a day?
Yes.
Okay. But if the camper decides, you know what, I want to have this relationship. So they started at the camp with the counselor, but they went to a different camp afterwards, then it would still be a criminal act. So is that correct?
That's
I
what
believe
the
so,
bill,
yeah.
that's what the part we're discussing says, yes.
Right. I'm just trying to understand what
Yeah.
we're talking about. So it seems to me that inconsistency, like, I understand what we're trying to do and I'm not opposed to it. I just feel like we're creating loopholes. I mean, like weird loopholes, it seems like. And it seems as if they let's say that they have a relationship and they realize that this relationship is illegal. So they make a decision for one of them to leave, so that it wouldn't be illegal anymore. But it's still illegal after they take the precaution of doing what they need to do to make it so beforehand it wasn't illegal. I know these are weird hypotheticals, but it just seems to me that we're creating some interesting dynamics, which are going to be weird fact patterns at some point.
All right, Delegate Grammer.
Yeah, thank you, Mr. Chair. And Claire and I tried to work this out. Claire, I have the reprint in front of me. Can you tell me why this closes the loophole with the amendment I have, the reprint I have in front of me, 203420? Can you more clearly elaborate for me why this closes or how this closes the perpetuity loophole?
Well, I think some people may have thought that this means that for the rest of the person's life, the rest of the two people in question forever, they could never have a sexual relationship. But that is not the case, because the criminal prohibition says a person may not engage in the sexual activity with a minor, and a minor is somebody under 18. So once the child turns 18, then it's never a crime to have a consensual relationship with
Where
them.
does it say that? Where in the bill, help us understand where in the bill that's covered? Because this looks to be a point of contention.
It's subsection C, like in paragraph 1 and paragraph 2, the lead-in language. A person in a position of authority may not engage in a sexual act or sexual contact with a minor who.
Okay, so what you're telling me is while the was previously enrolled language is there, it still only applies to minors. Is that what you're telling me?
Yes, this applies to 16 and 17-year-olds. The whole bill, the whole statute, the whole bill applies to 16 and 17-year-olds only.
Mr. Chair, have I closed the loophole sufficiently?
It's up to you. Delegate Cardin is still has questions about inclusion of the provision, it sounds like. So
I'd like to hear from Delegate Card.
well, let's hear from Delegate Kaufman. Go ahead. You need to unmute yourself.
Okay. Mr. Chair, can you hear me now?
Yes, go ahead.
So again, forgive me, I'm not a lawyer, but Delegate Cardin is the king of hypotheticals, and I appreciate that. But my question is, he said, well, if a 16-year-old and a 21-year-old wanted to have sex, could they do that? Well, isn't that covered so I can get a better handle? Wouldn't that 21-year-old counselor still get in trouble because of statutory rape laws, right?
No, 16 is the age of consent.
I thought it was 18. Thank you for clarifying.
No, it's 16.
All right, thank you for clarifying, Claire. Appreciate it.
Right. So right. I guess if you don't like the 16 statutory age, then you may have questions, or you may not have a question about this thing, about making it more continuing to be illegal even if you try to legalize the relationship by quitting the camp. If you just don't think people under age 18 should be doing this. So I guess that's part of the question of this this clause. So, what do folks want to do? In
Move
or out?
favorable.
Here's the only
Move
thing I'll say
favorable.
about it. I do like clarity of law so that people can very easily understand what's permissible and what's not permissible. I hope that what we're doing here is clear to the world, I guess.
So Mr. Chair, I don't know. I mean, there's a comment in the chat box from Joyce King saying Delegate Love and MSAA is comfortable with striking those lines. I'm not sure what lines they were referring to, but is that preceding this discussion, or is that about this discussion?
Oh, I think it's about this discussion.
Okay, so what lines are they willing to?
Well, just for the record, Delegate Love would love for this subcommittee to move it as it's written. I think Claire put a lot of work and we like the language it is, but if it remains a point of contention, we are willing to acquiesce. It would be the previously enrolled at a school or participating in a program, just so strike Roman numeral number 2. Our fear is that, in those situations that would be exploited, that you would then, the abuser would then just force the child to quit the program, knowing that is going to be a loophole that they're no longer enrolled. But, we're talking about hopefully a small group of cases. I think the way that it's written, of course, we would maintain that it's appropriate and to keep that language. But if it remains a point of contention, Delegate Love did want me to represent, she'd be comfortable with striking that.
Well, Delegate Bartlett.
Well, I think it's important that language. I think it's important. And I did hear a move favorable, Mr. Chair, and I would
On the
second.
amendments, on the whole set of amendments. We're on the amendments, right?
I heard a
Yes.
move favorable from Delegate Erica. Yeah, okay, and I would second that.
All right.
And
Is there any more, Delegate Cardin?
just want to, so I just want to be clear that we're creating, I mean, I understand that it might be rare, but we're creating some opaqueness in the law by doing this. I'm going to vote for the bill. I just wonder if there's a way to make it a little bit, so we don't give, like just saying, we're gonna give people an out by, by letting them leave a program. To me, I mean, okay, I kind of said my word. I'm not sure what the solution is. I don't necessarily have the solution. I just want to make sure we're clear that while we try and create very predictable laws, and we're creating an opaqueness here.
Yeah, I guess the rule would be if you want to do that behavior, don't work at the camp at all. Just don't make that your profession. Delegate Erican, do you have another
Look at a
comment?
different camp.
Yeah, I just wanted to say that, like, I think if we take that piece out, that's the actual opaqueness. I mean, I just feel like then the predator will be able to say, like, oh, like he could quit. Oh, I no longer work here, or she could leave the program, and then, oh, she no longer is a student there. So now we've allowed it, versus, the person has sort of established a relationship of authority with the child, right? So they were her teacher or her music, whatever, tutor. And so the sort of establishment of that relationship was where there was an unequal power structure. So just saying, like, oh, well, if she's not a student anymore, all of a sudden that doesn't exist, except for that was how the relationship was entered into. So yeah, I would like to move the previous.
Well, you can't move the participant in the dialogue. You can't move the previous question. But, having heard that, this bill hasn't passed for forever. So never passed. So that's the other bit I would flag. We're sort of stringing two interesting policy reforms together at the same time and hoping they move together, which I'm fine to do. But it also means to say, Delegate Cardin, that we will probably have another bite, because it would be interesting if the Senate just moves an identical bill to what we're doing. So let's go ahead and vote. All right, we have the amendment before us. All in favor of the amendment as presented in total, raise your hand.
Aye.
All right, does anyone want to be recorded in opposition to the amendment? No. Okay. Do we have anything else on the bill? Motion?
I move a favorable report on the bill as amended.
Second.
All right, all in favor of the bill as amended, raise your hand. Anyone opposed? No. Okay. Let's move on to Grammer's bill. This is accessing with intent to view pornography. Can we get this one's a simple bill. Can we get the text up on the screen?
Yep, 1 second.
I did a little bit of research into the federal child pornography laws and aggravating factors in preparation for this bill. And I learned way too much about a topic I didn't want to know anything about. All right, here we go.
All right.
Knowingly. So here's the one thing I'll flag for the committee that I noted in my research, and then we'll open this for discussion. Some of the aggravating factors with the feds were whether you were part of a community that was distributing, right? Are you part of chat rooms and things of that nature? They were looking at the volume of images and noting that with technology and speed and data transfer, the average defendant now was getting caught with huge troves of, thousands of images. So these are some of the elements here. The one flag that I think tracks to this that I think is interesting to be aware of is that the access with intent to view appears to be at least at that instant, a one-time instance, and someone else saving it for later use, is potentially doing more accessing, repetitive accessing. I would just flag that as an interesting thing that I noted in how some of these crimes are parsed out, saving them, distributing them, sharing them with others, and possessing lots of it. And I'll just flag that and move it for discussion. All right, Delegate Cardin, and then Delegate Erican, and then Graham.
Thank you, Mr. Chair, and thanks for all your research and work. So I'm going to do this on behalf of for Delegate Kaufman. I'll give you a couple of hypotheticals that just concern me. Number one is, and I believe there's an exclusion for like state's attorneys who might view because they're viewing it for the purpose of prosecution or investigation. Maybe not, but if I think there is, I think we had a discussion about this years ago and that was included. What about the principal or the resident assistant at the university who is worried about a person who's doing something and has the intent, streams it with the intent to view, to be able to, for concern of making sure that he's reporting what he needs to the authorities, or to address this with the individual, the student or whatever, it could be an employee, and saying, wait, you need to stop doing this. But they violate the law in the work that they did. That's scenario number one. Scenario number two is, let's just say that, I'll use Delegate Kaufman, went to play cards with his friends, and he, one of his friends had on the television or had on the computer something streaming that he didn't know that he was going to be seeing, but then he was there for an hour and saw something that he shouldn't have. Did he have, and he didn't stop. He didn't stop. So there's an intent issue there. So the issue I raised, and I actually brought this up once before, and I'll bring it up here, is, again, I see the value in this bill, but I'm thinking that, because I think it's important because of the technology and the way we've changed, but I think that maybe there needs to be a prurient intent as opposed to just an intent to view. And I'm not sure exactly whether it's defined for child pornography in the same way that it's defined, for the exposure of individuals, and how we did it with the Crosby bill and the Pippy bill. But maybe that if we could add that language so that, if you are seeing it and you realize you shouldn't, and you did, or you're doing it for other reasons, that you couldn't be prosecuted. So
all right, in the interest of, and I hate to make us have a fast convo, but your point is taken. Delegate Bartlett appears to agree. Let's Delegate Erican, and then Grammer.
Sorry, you can let Grammer go first.
Thank you, Mr. Chair. Yeah, to Delegate Cardin's first circumstance, keep in mind that there is an affirmative defense in the law. So if a teacher took reasonable steps to destroy the representation and reported it, that wouldn't necessarily create a case where they could be prosecuted. Also, keep in mind that the culpability here is that there's a knowing or intentional standard that's pretty much already in this section of law. So for a prosecutor to be able to make this stick, there's going to have to be a proven, when they talk about this issue, they talk about the actual access and how does that work? The clicking, you know, the searching, the intentionality of it. But with that, I wanted to actually see, because this language is what's suggested by the prosecution community. I was wondering if they were here, if they might be able to speak to that and just kind of clear this up for us.
Yes, that's what you stated, Delegate Grammer, is correct. I mean, in those hypotheticals as to, well, one, under the teacher hypothetical, that's already covered under the laws you stated, and that's not a streaming. There would be no instance. I mean, when you're talking about a video that has already exists, that is being possessed, that's already covered under the law. The expansion here is with regards to streaming live sex stream shows, and those are scenarios that are not captured in those hypotheticals. So I would.
Can I actually just pause there for a second?
Mm-hmm.
I don't think this is just limited to live streaming, like someone physically live real-time streaming. And in the sort of federal research I looked at, those cases were very small. That's like, 5 of those cases is mostly website access, like streaming off of a YouTube type service.
Right,
seems
links.
to be more what this is. Website access was a large category of the federal offenders, and I think that's probably more what this bill is going to impact.
No, I hear you. I think the difference is when you have a video that it already exists forensically, we can charge that under possession. So what this is capturing are when there is no hard file. So we're capturing forensic evidence like link files or things of that nature that just, they aren't the actual file themselves, but show that the individual was actually viewing this. So I think to everyone's concern that, are we going to capture people who accidentally view or, unintentionally view? We wouldn't, because in order to prove this, we need the corroborating evidence that they searched for it, that that they're on this particular website. And if this was, I think some of the other hypotheticals, what if this was just maliciously inserted in a regular movie that one was downloading? We would forensically see that, and that wouldn't be, you're not knowingly or intentionally trying to access it.
All right, Delegate Erican and then Embry.
I just wanted to move favorable.
Delegate Embry.
Joyce really said that what I was going to say. I think knowingly, intentionally language captures the concern that's been expressed.
Yes, and Delegate, Mr. Chair, I'd like to second Delegate Erican's move favorable.
All right, is there any further discussion?
I do have a question, but I can ask Joyce if she's going to be around today. I'll grab her and ask my question, because I actually did have to do this for a living. And it wasn't because it was fun. It was because when domain names first came out, everybody was grabbing every domain name that they could come up with. And a lot of times they had porn on them. And I had to review them to be able to, submit them into evidence, et cetera, et cetera. So I'll talk to Joyce about that. She says it's all covered. I'm going to take her word for it, and I'll be a favorable.
There's not a specific requirement to search for or seek out the videos in the law. Well, this is the intent question. This is something OPD is raising. All right, well, fair enough. Okay, but we do have a motion and a second in front of us on the bill unamended. Is there any further discussion? Okay, all in favor of the bill unamended, raise your hands. Is anyone opposed?
Thank you so much.
Okay, great. All right. Last bill is the facial recognition bill. I see some folks here for that, and I guess this is a real simple question because their colleagues, there were proposed settlement agreements essentially sent by the defenders and the prosecutors on this. But I've not yet heard whether one side has agreed to the other's latest versions. So can we just get a 1 second, Jake Parker or Andrea Mansfield or Elizabeth Hilliard are we close to a deal?
Well, actually, I guess I'll jump in first. Thank you, Mr. Chair. So we have had a chance to review the amendments. And actually, I think we do have some concerns with them. I know there was one amendment kind of still limiting the use of more open source data, or it was referred to as being illegitimate types of data, which is still a concern for law enforcement. In particular, there's one service that they use in particular called Spotlight. And I know that is one that they currently use for human trafficking and child sex crimes. So it would prohibit the use of that information for trying to solve those crimes. And I know that other changes were also made to the list of crimes that were provided in the document that came from law enforcement and Jake Parker's organization as well. And we have some concerns with narrowing that focus too. I know in terms of those crimes, I think in terms of where they talk about the extreme risk protective orders, domestic violence and conspiracy and child porn, that we may be able to accept those. But when it comes specifically to hate crimes, weapons, animal cruelty, and fentanyl distribution, we would have concerns not being able to use that type of more open source data to help solve those types of crimes. And I know Nick Bercerno was also on here from Montgomery County. He does these investigations all the time. So if it's okay, maybe if Nick could provide some comments on that too.
Well, let me just pause here. I don't think we're going to have time, unfortunately, to go too far into this. I was hoping we would have a deal cut by today, but alas, I think this will buy us another week to work on this, work out a deal. But hopefully we can send out final amendments next Wednesday that are more or less agreed upon by the parties so that we can roll in Thursday and vote. And colleagues, just so you understand what's going on here, there's sort of two big debates. One is what crimes can you use this powerful technology for? And so we're zeroing in on what that should be. And then the second big question appears to be here is basically what vendors can you use and what databases are they allowed to access? And the public defenders are now suggesting they are uncomfortable with technology that uses data and images that the person pictured has not consented to using in that manner. And so this would implicate, I think, anyone using social media photos for the search database, which is what I think a number of these vendors are in fact doing. So I suspect that's going to be a big discussion point. But anyway, more on that next week, it sounds like. And with that, I'll yield everyone the balance of their time, and I will see you all next week. Thank you all very much.
Thanks, everyone. Thanks, Claire.
See you at 1 o'clock.